Good afternoon, everybody. Thank you for being here. My name is Joseph Sturdy, and I'm a panel coordinator for the National Student Symposium. This afternoon's debate is entitled Presidential Power and Congress's Response. In the last 50 days, the scope of presidential power has been on the top of everybody's newsfeed, from legal battles surrounding USAID payments to the president's threats to seize Greenland and pull the country out of NATO. The second Trump administration has already ignited a great amount of critical commentary. That is what we are here today to discuss. How far does the president's power extend, and what can the legislative branch do to check the executive sweeping policy authority? On one side, Professor Julian Mortenson will make the case that the Article 2 vesting clause confers upon the president only the narrow power to execute the laws. On the other hand, Professor Michael McConnell will argue that the Constitution's grant extends far further. It is my great pleasure to introduce today our moderator and our two panelists. Our moderator for today's panel is the Honorable Judge Joan Larsen of the United States Court of Appeals for the Sixth Circuit. Judge Larsen graduated first in her class from Northwestern University's School of Law, and she began her legal career as a law clerk to the Honorable David B. Sentel of the United States Court of Appeals for the D.C. Circuit, and then clerked for Justice Antonin Scalia of the United States Supreme Court. Following her clerkships, she joined the law firm of Sidley Austin, where she was a member of their constitutional, criminal, and civil litigation section. Before becoming a judge, Judge Larsen was a faculty member at the University of Michigan Law School, where she was also special counsel to the dean and received the L. Hart Wright Award for Excellence in Teaching. Judge Larsen's research and teaching interests include constitutional law, criminal procedure, statutory interpretation, and for our purposes, presidential power. Judge Larsen continues to assist the law school as the advisor to the Henry M. Campbell Moot Court competition. And now to our debaters. Michael W. McConnell is the Richard and Frances Mallery Professor and Director of Constitutional Law Center at Stanford Law School, and he is a senior fellow at the Hoover Institution. He earned his Bachelor of Arts from Michigan State University and his JD from the University of Chicago, and he has received honorary degrees from Notre Dame University and Michigan State University. He served as a law clerk to D.C. Circuit Chief Judge J. Skelly Wright and Supreme Court Justice William Brennan Jr. From 2002 to 2009, he served as a circuit judge on the United States Court of Appeals for the 10th Circuit. He was nominated by President George W. Bush, a Republican, and confirmed by a Democratic Senate with unanimous consent. McConnell has previously chaired professorships at the University of Chicago and the University of Utah, and visiting professorships at Harvard and New York University. McConnell has argued 16 cases in the United States Supreme Court, most recently Carney versus Adams in 2020, defending a provision of the Delaware Constitution requiring political balance on that state's courts. More recently, he was co-counsel in Gonzalez versus Google. He is the senior counsel to the law firm Wilson, Sonsini, Goodrich, and Rosati, and is co-chair of Meta's Oversight Review Board. Professor Julian David Mortenson is the James G. Phillipp Professor of Law at Michigan Law School. Professor Mortenson received his Bachelor of Arts in History, summa cum laude, from Harvard University, and he was the salutatorian at Stanford Law School, where he received his JD. Professor Mortenson clerked for the Honorable J. Harvey Wilkinson III in the United States Court of Appeals for the Fourth Circuit, and then for Justice David Souter on the United States Supreme Court. Before joining the Michigan Law School faculty, Mortenson worked at the law firm Wilmer Hale and in the President's Office of the International Criminal Tribunal for the former nation of Yugoslavia. Mortenson's litigation practice includes serving as lead counsel in a pre-Obergefell lawsuit that required Michigan to recognize the marriage of more than 300 same-sex couples, acting as lead appellate counsel for the Arab American Civil Rights League's challenge to the Muslim travel ban, and advocating for discharged military service members challenging the Don't Ask, Don't Tell law before its congressional repeal. His current book project develops a comprehensive review of presidential power at the American founding. It seeks to establish a new historical paradigm for presidential power at the American founding through the lived history of executive power that shows that the 18th century president was understood not as the amorphous locus of unspecified sovereign rights, but rather as the pragmatic instrument of a legislative agenda over which the occupant of the office had enormous influence. Professor Mortenson is a frequent contributor to our chapter here, and we are thrilled to have him on the panel today. There will be time for questions at the end of this debate, so keep them in mind as the panel continues. And now I will turn over the floor to this afternoon's moderator, Judge Joan Larsen.
Well, thank you, Joseph, for those kind introductions. I am just delighted to be back here. As Joseph mentioned, I was on the faculty here for more than a decade, and my chambers are right down the road, but I don't get here as often as I would like, so it's really wonderful to be back at the law school. Today we have a debate, and we spent a fair amount of time hammering out exactly what the terms of the debate would be. So I want to read you the carefully crafted resolution, which the two sides will be debating. So the question on the table is, does the Article 2 vesting clause give the president any powers other than to carry the laws into execution? And before we started, I thought, well, perhaps we should read for you what the Article 2 vesting clause says. I will say this looks conspicuously like one of the missing constitutions, but it is not. I can tell you that it was presented upon the donation, I don't know, of some alum. So it looks like it, but it isn't one. Okay, so the vesting clause, Article 2 vesting clause, says, the executive power shall be vested in a President of the United States of America. One sentence. We're going to spend an hour and 15 minutes unpacking it. And we have with us just two preeminent scholars to talk about that subject. So with that, I will turn it over to Julian Mortenson, who I understand will take about 10 minutes to present his side of the case. Then Professor McConnell will have his 10 minutes. We'll have a little time for rebuttal, and then some questions from me, and then, of course, from the audience. So, Professor Mortenson.
Thank you very much, Judge Larsen. Is this speaker on?
Oh, you need to push the...
Red? There we are. Thank you very much, Judge Larsen. Thank you to the Michigan FedSoc chapter. It's great to see everyone here for a conversation about such an important topic. Particularly delighted to have the chance to welcome Professor McConnell, Judge McConnell, to Michigan. We've been in dialogue about these questions for a long time, so the chance to have the conversation here is something I've been looking forward to. I have slides and they are working, so that's good. That makes my plans run a little bit easier. I want to start by talking about the structural nature of the problem. And in some ways, just briefly biographically, the path that brought me to focus on this question, the answer to which I think is relatively straightforward, and its implications, which are not at all straightforward, for really the last 10, 12 years of my academic career. I graduated from law school in 2002, in the wake of September 11th, into the teeth of the opening of the global war on terror, and across a range of litigation activities once I did my clerkships, I found myself either advising on, participating in, reading about suits that were being brought to challenge something that the administration was doing on the national security front. And it was remarkable to me how often, across wiretapping, across torture memos, across conversations about the use of force, about questions like the application and interpretation of international law, something that was called the vesting clause thesis kept popping up to be sort of the ultimate trump card for why the president ought to win in some dispute about whether the president has the authority to take some action. Give a simple classic example of a federal criminal statute that, this is all coming from Office of Legal Counsel memoranda, that prohibits torture. Generally applicable federal criminal statute prohibits torture. It is defined in that statute as the intentional infliction of physical or mental pain or suffering on someone who is within your custody or physical control. The same OLC describing waterboarding had a lot to say about waterboarding. Try to keep the slides short. It says this, among other things, about waterboarding. Waterboarding inflicts the uncontrollable physiological sensation of drowning. It constitutes a threat of imminent death. Now, the department had arguments why this statute didn't cover the behavior in question for a variety of reasons. But a theme that emerged in the arguments in these memoranda made the move that has sort of turned into, the great white whale of my academic career, which is the statement, blunt, straightforward, that any effort to apply federal criminal law in a manner that interferes with the president's direction of the detention and interrogation of enemy combatants would be illegal. To make a claim like that the statute itself is illegal, that is to say unconstitutional, you got to have some articulated theory for what in the Constitution prohibits the application of an even-handed, generally applicable statute prohibiting torture. And if you take a tour through Article 2, there just aren't that many affirmative powers that are given to the president. There's lots of process powers. The president can participate in nominations of officers and judges, participation powers in creating treaties, participation power in being part of the legislative process with the veto. But if you look for affirmative substantive grounds in the Constitution that give the president some affirmative sphere that only he or she can control, they're few and far between. And so the question becomes, setting up why these questions matter, how do we think about the claim that Article 2 entitles the president to ignore, break at least some statutory laws, at least sometimes? This theory floated around more in scholarship than in actual official circles for about 10 years, and has reemerged with a vengeance under the first Trump presidency and now again in the second Trump presidency. The phrasing here is inartful, but where Trump says, I have an Article 2 or I have the right to do whatever I want as president, he's speaking the words of somebody who's being advised about constitutional authority to ignore statutory frameworks and statutory obligations on the basis of Article 2. That's the advice that he's getting and hearing, and it is principally, although not only, because of the vesting clause thesis and the things it is said to convey. Very big picture. 3 vesting clauses in the Constitution. I think about these as the load-bearing architecture of the Constitution. 3 different kinds of government power, 3 different institutions, allocation of portions of the power to each of the 3 institutions, and the first sentence in each of the 3 articles is part of an interlocked, structurally parallel, complete statement of the sorts of powers that the federal government has. The executive power is the power that is said, that has been said, to create substantive authority for the president over a wide range of foreign affairs, national security, and emergency questions. It is said to have been a reference, a standard reference, a term of art, to reflect a bundle of authorities that executives, particular 18th century executives and probably the British Crown as the archetype, possessed as a matter of their being executive. What is the executive power? This thought goes, it's those powers that typically belong to executives. So I got pulled down the historical rabbit hole, and it's become more of a joy than a rabbit hole over time because the research is fascinating. These disputes then and now tend to involve very high stakes, complicated legal regimes and very high stakes political questions. It seemed to me when I read Blackstone, my very first step in trying to figure out just how much does this argument hold up, that Blackstone rejects the idea that the executive power refers to a substantive basket of authorities. To the contrary, he says quite explicitly that the executive power is the power to execute laws, legislative power is the power to make the laws. Now, it's just one person. It is Blackstone, but it is just one person. And so what I launched on was a project across years of work, millions of words, tens of thousands of documents, digitized and not, reading every discussion of the concept of executive power over about a 20-year period in the political sphere in North America, as well as what I think of as Madison's bookshelf, the regular tomes and references that a well-educated lawyer and public citizen would have had on his or her bookshelves or would have been aware of as being reliable and important sources of information. I expected to find contestation. I expected to find sort of the old historical, it's complicated answer. As time went on, I found myself more and more surprised not to find any evidence for the proposition that the executive power in a cluster of 3 allocated powers in a government meant anything other than the power to execute the laws. Lots of evidence that executives participate in foreign affairs, lots of evidence that executives play an important role in emergency situations, in taking the lead, and being forceful and being vigorous. But in terms of a suite of legal powers that were granted as like a bucket of stuff, there wasn't evidence for that at any point that I saw during any of the work that I did over many, many years of a lot of reading of an incredibly broad array of sources. There was a term for it. It was the prerogative. The executive prerogative was a basket of authorities, and that's what they called it when they were referring to a suite of authorities that an executive possessed. So, what is it instead? The complete government framework. They use the word complete, it's not mine. They use the word perfect, it's not mine. Perfect in the 18th century sense of not lacking anything. The idea is that the vesting of the 3 powers, with judicial actually being conceptually a subset of executive power, for what it's worth, the vesting of the 3 powers in a single government made that government perfect. And this was important because of the radical imperfections, incompleteness, and sort of incoherent inability to effectuate policy, enforce law, do things that were meaningful, not only of the Continental Congress, famously, but also of the state governments. So when they talked about what is executive power, what is legislative power, I'll read you a bit from Rousseau that is the utterly standard 18th century body metaphor for talking about legislative power and executive power in a governance context. You will see the psychology is naive by our standards, but the upshot is clear. Every free action is produced by the concurrence of 2 causes, one moral, the will that determines the act, and one physical, the power that executes it. This is an observation about action in general, and in particular, action by humans. It's like a brain-body explanatory mechanism for talking about how human cognition, perception, and behavior works. Very naive as an account of how the body works, but deeply explanatory of how they thought about the interlocking pair of legislative power and executive power. He goes on to say, and you could pick any one of a number of people for this, I just like the way he puts it because he writes well. When I walk towards an object, it is necessary first that I should will to go there, and in the second place that my feet should carry me. If a paralytic wills to run and an active man wills not to, they will both stay where they are. In other words, you have to have an alignment of the instruction, the will, the command, the direction, the orders, and a body that is capable of exercising them. Then he goes on, and again, in utterly quintessential, uncontroversial fashion, talks about how this metaphor is what they mean in the late 18th century across a broad range of legal cultures and political theorists talking to one another in which the framers and founders were deeply immersed. The body politic has the same motive powers. Here too, force and will are distinguished. Will, under the name of executive power, legislative power, and force under the name of executive power. It's embarrassingly simple. Legislative power is the power to issue authoritative instructions authoritative prohibitions, authoritative authorizations. It's the brain of the body public. Executive power is the power to take those instructions, whatever their proper source, and implement them. This is not theoretical rocket science. It's one of the reasons that it's a little bit strange to have spent so much time digging into something so simple, but it's my claim that the executive power was actually an extremely straightforward authority, the authority to execute instructions that had to be created by some source of legislative power.
All right. Oh, thank you, Professor Mortenson. We will now hear from Professor McConnell.
Thank you. Is this on? I turned it.
Now it's on.
It's on when it turns red. This is counterintuitive, let me say. But
Especially in Michigan, where we say go blue, not red.
So thank you first to the organizers for inviting me. It's always good to be back at the University of Michigan as a Michigan State Spartan. I got down here a few times as an undergraduate. It was always intimidating then. Not so intimidating anymore, but thanks for having me, and thanks to all of the people in the audience today. I've come to quite a few of these. I was at the very first ever Federalist Society Student Symposium back in the early 1980s, and I always enjoy them. But I especially appreciate having been invited to speak on a debate. I don't know if we're debating or speaking, but with Julian Mortenson, whose work I very much admire. I learn a lot from it. I don't know if Julian considers himself a quote-unquote originalist, but he does originalism, and that means we have something we can actually talk about. Like, we can agree upon the history and what does this mean? And it's just such a pleasure to talk to somebody who knows what he's talking about, has done such great work in the area. I get tired of debating with people who think that the idea of a good argument is to raise your voice. But that said, I think that Julian's thesis is just demonstrably incorrect. Before I get into that, though, I do want to correct what might be not a statement, but a misimpression. So Julian began his talk with the incident of the torture memos, which has to do with the president disobeying a law. That's not actually what the vesting clause is about. At least under my reading of the vesting clause, which I'm going to lay out here today, the vesting clause gives the president the authority to act in matters that are executive in nature, but when Congress has enacted statutes within its enumerated powers, they trump the executive power. So in Julian's terminology, and actually mine as well, this means that the executive powers under the vesting clause are, quote, defeasible. That is, they exist. President has first mover authority, but he's ultimately subject to the authority of Congress. This is in contrast to prerogative powers, where the executive has the power both by virtue of his constitutional standing, but also those powers cannot be regulated, diminished, or taken away by Congress. Examples of that would be such things as the pardon power or the veto power. You know, the powers elsewhere in Article 2 are prerogative powers. The power vested by the executive power clause is not. Now, why do I think this is also rather clear. Let me see if I can get, oh, here we go. It's already, oops, if I mess this up. How do I get forward rather than back? Somebody know how to use this?
You did it.
Oh, okay, excellent. So let's begin at the beginning. On the third day of the Philadelphia Convention, when Governor Randolph is presenting the Virginia plan, on that day they get to the provision for the national executive. They didn't yet call it president, so it's just called the national executive. They didn't know at this point whether it was going to be one person or more. They just called it the national executive, and it provides that And the entire provision for the authority, for the powers of this national executive are that in addition to a general authority to execute the laws, it ought to enjoy the executive rights vested in Congress, meaning the Congress under the Articles of Confederation. Now, I thought I had a second slide here, but here it is. Somebody else seems to be doing my work for me. Thank you. So our topic today is, does the vesting clause give the president any powers other than to carry the laws into execution? And Julian's position is that he's read, millions of words, lots of things, and is unable to find any examples of where the term executive power is used to mean anything more than or other than the power to carry the laws into execution. Well, that would have come as some surprise to the delegates to the Philadelphia Convention, because as you can see, they had before them the Virginia Plan, which gives the new national executive two things. One thing it gives them is the general authority to execute the laws. That's what Julian says is the only thing at stake. And, I emphasize the word and, the executive rights vested in Congress by the Confederation. Now, even without knowing what the executive rights vested in Congress by the Confederation were, we know from the word and that at least something is being given to the executive other than the thing that Julian says is the only thing that is included with the term executive powers. By the way, it does say executive rights. Don't get hung up. I'm quite confident, I doubt Julian would disagree, executive rights means executive powers. In the corresponding provision for the Congress, it refers to legislative rights and then lists many of the things that are now in Article 1, Section 8 and are in fact legislative powers. So executive rights. So how is this read? Immediately, without anything, without any explication from the drafters, Charles Pinckney of South Carolina sort of gasps and he says, why, that would give this new executive authority the powers of peace and war. Why, that would make him a king. By the way, he says, Madison's note says peace and war, etc., which I don't know whether Pinckney said etc. or whether Pinckney listed a bunch of other things that Madison summarizes, etc. But it isn't just peace and war. Well, why would anybody think that the powers of peace and war are comprehended within Congress's powers under the Confederation? Well, Congress under the Confederation had the powers of peace and war, and so did virtually every other executive in the world. Certainly King George over in London had the powers of peace and war, and some very considerable et ceteras. So we know as a fact that the term, we're talking about definition of words here, we know that the words used in the Virginia Plan, they use the term executive power to mean something considerably more than just the power to execute the laws. Well, this did not go over well. It was not a popular idea, and immediately James Wilson says, oh dear, we don't want to make the king's prerogatives, and he uses the term prerogative to be the measure of this new executive powers, and they ended up adopting an extremely abbreviated version of this clause, and they don't return to it for a month and a half, and then the Committee of Detail does all the very serious work on construction of the executive, and what the Committee of Detail does is they allocate, like explicitly or implicitly, I think virtually there's only one clear exception to this, every prerogative power of the king that was listed in Blackstone is given up, but not all to the executive. Many prerogative powers of the crown are given to Congress. According to one account, and the numbers don't really matter, but something like 13 of the 27 specific powers given to Congress in Article 1, Section 8 were listed in Blackstone as prerogative powers of the crown. Well, and then they say the executive power, then they come back with the vesting clause again that had been eliminated in the early debate. And at this point, it is the prerogatives have been given out. What is left for the executive power? It's the other royal powers that were not prerogative in nature, which is to say very considerable powers of an executive nature, but not indefeasible. Now, we also know for sure that the first Congress adopted this view. So in the adoption of the creation of the Department of Foreign Affairs, they create the department, and this I'm reading from the statute here. It charges the secretary with performing, quote, such duties as shall from time to time be enjoined on or entrusted to him by the President of the United States relative to, and it lists a number of foreign affairs, and then it says, or other such matters respecting foreign affairs. So entrusted to him by the President. But where does the President get the power to create these powers and to give these instructions? Not from the statute. It's not in the statute or any other statute. It must be from the Constitution itself. Now, is it from the three specific foreign affairs powers given the President? That is, to appoint ambassadors with advice and consent, make treaties with advice and consent, and receive ambassadors. Foreign affairs powers are vastly broader than just those three things. And all of them, the first Congress presumes that they are vested in the President. Now, where do they come from? It seems to me perfectly clear that they come from the vesting clause. And indeed, that's what leading founders said about this. Hamilton has the most famous statement of this. This comes from his Pacificus essay in defense of the neutrality controversy. Since I'm running out of time, I'm not going to read it to you, but it's quite famous. Less famous is an official written opinion by Thomas Jefferson as Secretary of State in 1790, in which he says, and I quote, "The transaction of business with foreign nations is executive altogether. It belongs then to the head of that department," that is the executive department. He's referring here to the vesting clause. "Exceptions are to be construed strictly," and he goes on to say that this gives the president, they're arguing about whether President Washington has the power to determine the titles, the rank of various foreign affairs ministers, and he says it belongs to the president. It may not have been, he doesn't say it's part of the enumerated power. It is, he says, that the foreign affairs has been given to the executive branch in general. Madison makes an extremely similar argument in favor of the removal power. Three other people in the House of Representatives make this. The Jefferson opinion was given to Washington in his diary. He says he shared it with Madison, John Jay, and that they agreed with it. So let's look at the evidence here. Not only do the words used by the convention clearly indicate that the executive power goes beyond merely law execution, and the first Congress passes a major piece of legislation that presumes that to be true and treats foreign affairs as being within it, and we have express statements by Hamilton, Jefferson, Madison, three other members of Congress, and apparently joined in by Washington and Jay. This is the entire spread of opinion among the prominent founders of this country. I'm just baffled that anyone could conclude that there is no evidence in favor of this position.
All right. Professor Mortenson, I'm guessing you're less baffled. So we can briefly hear a response from each of you. 5 minutes or so, and then we'll get to some questions? Oh.
Okay. Thank you. 5 minutes, and then very much looking forward to the conversation, the continuing conversation up here, as well as Q&A from you guys. I want to say about Professor McConnell's theory that it's it's a big compliment to say McGonagall, right? I want to say about Professor McConnell's theory that it is elegant, it's beautiful, it's carefully wrought. He's working through a complex set of observations about a more or less consistent set of English views on what the content of royal prerogative was. He's tracing them in a sophisticated, careful way to places in the Constitution that those things appear. He's suggesting that there is a residual interaction between the executive power that exists except insofar as one of these other prerogative powers. And then he also suggests that this is the one clause, I think it's the one clause, perhaps I'm wrong, in the Constitution, or certainly Article 2, that is defeasible by a congressional statute. It pulls together lots of nice stuff. It has the attractive result of leaving no foreign affairs gaps in the Constitution, even when there isn't a statute. And it keeps Congress in the driver's seat because his emphasis that it's defeasible lets Congress come in second to reform, alter, or shift going forward. The difficulty is that there's no reflection anywhere in any of the conversations that they talk about Article 2 that comes anywhere close to describing the operation of the document in this way. Everyone treats the executive power throughout ratification as this completely mundane, boring, uninteresting vesting of power that everyone knows needs to be vested. If you're going to assume a defeasibility characteristic of the core grant of presidential power, that would have come out somewhere. If you're going to assume a complicated relationship between a really long list of very particular powers and their allocation at various points across a long document, somebody somewhere would have said something. What happened instead in the ratification conventions and in the most heated pamphleting debates with attacks on the president as a monarch was this. The anti-federalists, those loosely speaking, who opposed ratification for a variety of often internally consistent reasons, would Patrick Henry pounding the table, probably literally, about the tyrant that has been being created by this single man with a veto and with the executive power. And it slouches towards monarchy. The squints towards monarchy, thank you. The intensity and the passion with which they warned about kingship in these debates is astounding. And in the context of those debates, where they just finished talking about how dangerous the king is, they then start walking through the text. Nobody says anything about Article 2's first sentence. Nobody says anything other than, well, of course you have to have the executive power. The laws need to be executed. The North Carolina Convention is hilarious if you are easily amused and reading a lot of old dry documents. I mean, it's pages of like over the top, paranoia, like the old school country paranoia about central power. And then they read the first sentence of the Constitution. A long silence ensues. We know this because the next recorded observation is from a Federalist in North Carolina who says, "Whence the long silence, my friends?" and emphasizes, you keep saying how dangerous this officer is. We've just read the first clause of the Constitution. Where is the danger? What snake in the grass is there here? As he talks about the range of authorities in Article 2. That just isn't a close call. When they talk about the executive power, especially in the context of talking about the structure of the vesting clauses, it simply is the case that there is zero discussions that are anything like what Professor McConnell says, and dozens of discussions that are like what I've said. I want to pause before still under 5, I think. I want to pause before handing the mic back over to jump to, I'm trying to go to Professor McConnell's slide. Well, I can't find it. If one of you guys can find the slide, that would be fantastic. There it is. I want to urge you to think about, during Professor McConnell's presentation, how often he used the word the executive power when describing about the distinction that was made in the Virginia plan. The executive power does not appear in the Virginia plan. What happens when this weird phrase, the executive rights, appears? I have been unable to find another instance of that phrase in easily searchable databases. The idea that that is a term of art in the way that the executive power was absolutely a term of art seems simply to be incorrect. It looks hastily drafted, as much of the rest of the Virginia plan was. And so what happens when there's this weird phrase that nobody really knows? You're talking about executive rights. What is that? We know what the executive power is. What's executive rights? And Pinckney stands up and does the standard, this is going to be a tyranny. This will be the basis to insert the prerogative. Remember, the prerogative being precisely that basket of authorities that modern vesting clause thesis proponents insist is in the executive power clause, except as otherwise reallocated. The next three people all jump up and say, no, nobody had any idea of doing that. And then Madison, one of the co-authors of the plan, says, oh, of course I'm not saying that the president has any powers other than the power to execute. We'll have to rewrite that, no problem. And so the phrase used here, plausibly, in an intensely paranoid age, would make people think of the royal prerogative that had been used with such abusive effect in their recent revolutionary memory. But it was not the phrase the executive power, much less the phrase the executive power, in an interlocked system of load-bearing struts at the basic structural level of the Constitution. And the response to it, the rejection of the proposition that it ought to be seen as carrying prerogative authorities, I think makes the episode look much worse for Michael's thesis than for mine. But then I would.
All right, Professor McConnell.
Well, thank you, Julian, and thank you, Judge Larsen, for turning on my microphone. Better than having you turn it off in the middle, which is what usually happens. At least in court, right, when you run out of time. First of all, I want to acknowledge one argument that Julian made that I think is an excellent argument, and I don't have a perfect answer. I don't have an answer for it at all, except to say that it's overwhelmed by the other evidence. And that is the point that during ratification, none of the Anti-Federalists mentioned this, and surely you would certainly think that they might. By this I mean that the vesting clause imparts substantive power beyond what is specifically enumerated thereafter. It's a good point. I can't say anything other than this, and I talk about this for a number of paragraphs. And by the way, the book, get the full story, the president who would not be king, it is available on Amazon. And if you want an originalist account of like the whole executive power episode, please take a look. So the argument from silence, I'm just going to concede that is quite a good point. The idea that nobody mentions this, though, that the defeasibility, this is exactly what Hamilton and Jefferson say, is that the executive power is power of an executive nature with such exceptions and qualifications as are elsewhere, which includes all of those previously royal powers that have now been vested in Congress. So when Congress is exercising one of those powers, it's an exception to the executive power. Now, they may not have called it defeasible, that's a more modern term, but that's what they meant by it. And so one of those powers is the power Congress has the power to make rules for the regulation of the conduct of the armed services. This is what the so-called torture memo debate was all about, and it's why I totally agree with Julian's conclusion about that. Congress is given an enumerated power. They pass two statutes, which, if interpreted, a certain way, and that's not what we're arguing about, made the enhanced interrogation techniques unlawful. The OLC says, "Oh no, that's trumped by." They didn't use the word Trump. Good thing, I guess. That's trumped by the commander-in-chief power. They were wrong about that, I think, because it's not trumped. The Congress's enumerated powers prevail over the executive powers in the vesting clause, not the other way around. Now, they didn't come up with this. It wasn't just them. This had been an argument for a long time, and perhaps most conspicuously, it was the argument of Harry Truman's Solicitor General in the steel seizure case, rejected there, and I think rightly so. So the idea of defeasibility does not come out of nowhere. This is exactly what the explicators of the clause said at the time. Now, Julian has a reading of the way the debate went on that first day. The way I see this is, yes, Madison probably wrote Resolution 7, and then why would they suddenly assume that executive rights includes prerogative powers? Because look at the Articles of Confederation and at the executive type powers that were vested in Congress. Congress had the power to make war, it had the power to make peace, and a number of other powers. They were executive type powers vested in the Congress under the Articles of Confederation. And lo and behold, all it takes is young Charles Pinckney pointing it out, and they suddenly realize, oh my goodness, the idea of executive powers that were vested in the Congress should now be in an executive magistrate. That's a much bigger thing than we realized. And so they rapidly erase that then, and then a month and a half later, they come back in the Committee of Detail. Unfortunately, all we have are the drafts. We do not have any notes about what they said or thought. But in the drafts, what they do is they allocate the prerogative powers mentioned in Blackstone between the executive and the Congress. And many of the prerogative powers given to the president are actually cut back relative to their size and under the British Constitution. They're actually very careful about all of this. And then what about all the other executive powers? They can then have a grab bag without it being dangerous. It's not dangerous because the most dangerous powers are the prerogative powers, and they've already been dealt with elsewhere. And these can be overridden by acts of Congress. So, it doesn't present the specter of a new king, like an overwhelming, like a tyrant or a monarch. What it does is it presents it's not a specter, the attractive vision of a president who is able to respond to uncertain future events through acts of an executive nature, but subject to the control of Congress. And it makes sense of everything that they said. It doesn't make sense of the silence at the ratification, but it makes sense of everything else.
All right. I have a few questions that I thought I was going to ask about how this might affect sort of modern controversies. But before we do this, I think it might be useful just for the students in the room, many of whom are 1Ls who have just taken con law, to think about this in Youngstown terms. So we've heard this debate, and what I hear Professor Mortenson saying is that if we think about our Youngstown typology, zones 1, 2, and 3, the president has everything in zone 1, everything Congress gives him he can obviously do. He also has everything in zone 3, that is the things that are specifically granted to him by the Constitution, the power of pardon, the power of veto, presumably Professor Mortenson doesn't think that Congress could interfere with those. But there is no Zone 2. The Twilight Zone does not exist. And I hear Professor McConnell saying there's Zone 1, there's Zone 3, and there's also Zone 2. Zone 2 is all of the formerly prerogative powers not allocated elsewhere and subject to defeasement by Congress. So Zone 2 belongs to the president in the first place until Congress acts. Is that an accurate description of the debate to sort of frame it in an easy way for the students to understand?
I hate to say no.
Dang, I thought I'd gotten an A in the class, but I guess
really
not.
hate to say no, but it's a useful no, right? It's a useful no. I read, I mean, Professor McConnell should speak for himself. I read your characterization of how he thinks about these things correctly. One of the most important things to recognize is that the executive power requires a source of legislated instruction in order for it to have anything to do. There must have been a willed, legislatively authoritative act, statute, instruction, proclamation. But that doesn't necessarily have to come from Congress. What does that look like in terms of a universal field theory of how other laws at a time where people thought about the general common law differently, international law differently, what does that look like? I frankly don't know, and I don't think they did either. But it was a completely standard move. And it is totally explanatory of some of the most significant episodes offered by vesting clause theorists. For the president to say, international law authorizes or requires the following. I'm going to enforce it. I don't know if we'll have a chance to talk about the neutrality proclamation, but again, as I said, when I first came to these questions with the view that surely there must be some there, for the confidence with which generations of people in the White House had been making this claim, I was shocked to read the Neutrality Proclamation. All the Neutrality Proclamation says is I'm going to prosecute violations of the international laws of war. That is taking the legislated instruction, do not violate the laws of neutrality, embedding an interpretation in it, I must interpret it to decide whether it applies or not. I interpret us to remain in a neutral posture. What follows? If you violate neutrality, I shall prosecute you. That is Zone 2 in a broad sense, in the sense that it doesn't require congressional authorization, and in the sense, I assume, unless you have a very robust view of natural law in late 18th century thinking, I assume must be overridable by Congress, but it doesn't exactly map onto the Zone 2-3 framework in the sense of action without any authorization other than the Constitution itself. It is, I'm afraid to say, an empty vessel.
How about one prime? In other words, the laws enacted by Congress plus other sources of law that would have been generally recognized at the time of the founding international law, the general common law. And then I'll let Professor McConnell respond.
I could answer for Julian. I think he and I agree. He and I agree that it isn't, the law isn't just statutes of Congress. It's common law, international law, treaties. I mean, there are other sources of law. So I don't think that's the problem. I like Judge Larsen. I like your formulation with the you have made Jackson's three-part test conform to what I have to say. That's good. Rather than forcing me to conform to his three-part test, I have a short chapter here which I would recommend to those studying Con Law 1. It's an attack on the three-part test and why it's misleading in a number of small ways, but in the big way that you described, Judge Larsen, I think that this is right. Neutrality proclamation. Julian says that all Washington warns is that he's going to prosecute under international law. No, because the content of international law depended upon whether we were an ally of France or neutral toward France. We had a treaty of amity with France dating back to the time of the American Revolution. So America was allied with France. France is now at war. Under international law, Americans had the right to take actions against Britain because we were not a neutral power. We were an allied power. Once we became a neutral power, it became unlawful under international law for Americans to take up arms against Britain. The most concrete example of this, of course, being privateering, because lots of people loved, privateering is like piracy, only legal. It's a very profitable business, and lots of Americans, especially pro-French Americans, wanted to engage in privateering. It was okay the day before the Neutrality Proclamation, the day after it, because if the president has the right to decide whether we are neutral or not, if he has that power, then there are implications of that for international law, also domestic law, and a bunch of other implications as well. So the question is, does the president have the authority to decide whether we are neutral toward France or whether we are allied with France? That is not nothing.
Okay, I had hoped to ask some contemporary questions of our panelists, but we only have about 16 minutes left, and I always like to hear from the students. So I think I'm going to turn it to the audience for questions, and if you don't have enough, I've got plenty. So, oh gosh, I have to call in people. Well, let's take this gentleman right here. I'm going to guess you're from Notre Dame Law School.
Michigan.
Oh, well, go blue. You're just sitting next to a Notre Dame guy, so guilt by association.
Yes. Thank you all for being here today. My question is for Professor Mortenson, and I wrote it down, so I'm just going to read it. Some people use the Article 1 vesting clause, the inclusion of here and granted, as dispositively showing that Congress is limited to its enumerated powers. So I'm wondering if you think that since there's no here and granted similar language in Article 2's vesting clause, if that could be an indication of non-enumerated powers of the president.
It's a terrific question. I think the textual move basically works. I don't think it's decisive, but I think it basically works as an argument. I will reflect back to you that it is a historical matter. They leaned in hard on enumeration limits when it came to presidential power in talking about whether to ratify, that the only powers the president had were those who were enumerated here. Ironically, emerging research from folks like Richard Primus, who I think I saw here in this room earlier, has emphasized that some of that enumeration talk was not so salient and indeed rejected in the legislative context, which is a little bit mind-bending if you've been educated at American law school in the last 30 years. But in terms of what the actual historical conversation looked like, there was no question that the powers granted to the president being only what they said and nothing more was at the heart of the ability of the Federalists to say, don't worry about it. He won't have all that much power. Just any power that Congress gives him by statute, which turns out to be a whole lot of power.
All right, I want to go to this side of the room. So, gentleman with a blue shirt. Yeah, that's you. Blonde hair, blue shirt. I can't do better because I don't have a seating chart. So.
Yeah. So I guess my question is about some of the lessons about executive power from United States versus Texas in the 2023 session, and kind of where this line of background principles of discretion leads to kind of not following the law, and how we think about that moving forward with this administration. Thank you.
I'm not going to defend every bit of the opinion in that case, but here's the core of it: that there are certain exclusive powers of the president, the powers that are given to the president exclusively that Congress can't speak to. I think those are the prerogative powers like, pardon and others, and he can't be prosecuted for them. And I think the reason he can't be prosecuted for them is that neither Congress nor anyone else has the power to regulate his use of those powers. And that seems, I'm curious to see if Julian disagrees with that, but that seems to me to follow from the nature of the idea that there are certain powers that, that are vested in the president, subject to no one else's whim. Now, there may, exactly what those are and whether the indictment having to do with January 6th touches on them as a matter of some detail.
I think did you ask about United States versus Texas? Are you,
Did I answer the wrong case?
I think you were talking about Trump immunity.
I was, yes.
So,
sorry.
United States versus Texas, as I recall, there were a million cases named like Texas versus Biden, Texas versus, some secretary, United States versus Texas. So, I think United States versus Texas is the one where there's a command that says that aliens who have been found to have committed crimes shall be deported. Yeah, and so the question is whether that shall be deported language binds the president and whether he has to deport. That was your question?
I apologize for jumping to the wrong case.
I mean, it was a pretty salient case.
This is governed by the Take Care Clause rather than the Executive Power Clause. If all we had were a vesting of the authority to execute the laws, then that would look like the president either can or can't execute. We don't have that. What we have is a duty. The president shall take care that the laws be faithfully executed. Now, there is an uncomfortable and difficult to define boundary between refusal to execute and prosecutorial discretion. But my personal view, and I think one can, there are reasonable arguments about President Obama's action, either side, but I think he was on the wrong side of that. And when President Trump says that he's not going to enforce or instructs the Department of Justice not to enforce the Federal Corrupt Practices Act, I think he's clearly on the wrong side of that, and I think it's unconstitutional.
All right, I'm going to move over here to this side of the room. How about this gentleman here on the aisle? Yeah, that's you. Oh, sorry. Have to wait for the microphone. Yeah.
I wanted to go back to something mentioned at the beginning with executive powers being the emergency, like in emergencies, those type of powers. Do you think those, like the executive powers to act in an emergency, come from the other executive powers, or is it like an additional, like break glass in case of emergency powers?
The account that I'm trying to develop and present doesn't think that there are legal constitutional emergency powers beyond those that are in the Constitution, acknowledging that's begging the question to the extent that sometimes you infer the existence of authorities in the periphery of other authorities, but at least as a starting point for the conversation, reflecting what they understood the presidency to be, it was an entity of strictly limited powers that everyone knew was going to be extremely important, extremely influential, and potentially frighteningly powerful. But the reason for that was the president's chief power, the executive power, gave the president not only but including the power to execute statutes. And once you have Congress with a range of regulatory authorities and sort of has its act together, a new architectural structure, and a president who's authorized to execute those powers, you've got a very powerful president, especially when the president has the single biggest lever on what legislative policy looks like of any single person, because he can veto. His vote, it's only a negative vote, but ask anybody who's done negotiations how much power the veto gives you. His influence in the legislative process was enormous. So to come back to how that's all relevant to your question, from the very beginning, Congress enacted statutes that were meant to create residual emergency authority. And from the very beginning, presidents complied with their provisions and strictures, such as they were, I won't say religiously, very carefully. It's indeed remarkable how compliant presidents were about judicialized proceedings that were required prior to, let's say, calling out the militia.
Can I just say, there are no emergency powers provisions in the Constitution. That doesn't mean that some of the powers that are in the Constitution are not likely to be invoked in the time of an emergency. As I think about it, there were at least two discussions about what we would consider to be emergency powers. They didn't use the term at the convention. The most important one being repelling sudden attacks. The president is not given the power to repel sudden attacks in the text of the Constitution. He is assumed to have the power to repel sudden attacks, as we see that in the Congress's decision to reduce the scope of Congress's power. I just said Congress, the convention's decision to cut back on the scope of the congressional war powers from the power to make war to the power to declare war, and they believe that that would mean that Congress can't interfere with the president's authority to repel sudden attacks. Now that's an emergency. They assume that he has that authority, but when it comes to domestic insurrections, and the use of the militia, which are also all of these are emergencies. The president can only call forth the militias into federal service upon the occurrence of these three particular emergencies, and then only by authorization by Congress.
Okay, how about this guy all the way in the back?
Thank you. When it comes to looking at the aggrandizement of executive power, a lot of that can be traced back to Theodore Roosevelt, who famously subscribed to the stewardship theory of the presidency. He felt that executive power was limited only by specific restrictions and prohibitions appearing in the Constitution and passed by Congress, and that the president, as the only nationally elected figure, was best fitted to be the steward of the people and not Congress, even though that's popularly conceived as the representative branch of the citizenry. How do you feel this conception of presidential powers holds up against the founding debates about what executive power should be, and how has the emergence of this view of power changed how the executive functions?
My sense is that Professor McConnell's theory of the executive power as a pruned down prerogative that can be overridden by Congress maps on pretty well across century and a half to TR's thinking about when the president could do things without statutory authorization. Roosevelt wasn't a deeply sophisticated theorist, but I think my sense is that really important. I'm not saying he was dumb. I just mean that the theory wasn't particularly complicated. My sense is that it maps onto Professor McConnell's views, at least potentially.
I think they may end up in the same place, but the idea that the president represents the people, and more so than Congress, I don't think anybody at the founding would have agreed with that. They all thought of Congress as being the representative of the people. And there was still a kind of distrust of executives. You see this in the very way in which Hamilton begins his great paper on the executive power. He says, there's a lot of belief out there that a powerful executive is anti-Republican, and he proceeds to refute that, but he doesn't go full TR. I don't think anybody would have gone full TR. In theory, now that isn't, I'd like to know what TR actually thought he could do and when before, just like, Trump says absurd things about being able to do whatever he wants to, and I'd just like to know, what are the specifics?
Okay, let's take blue shirt, light blue tie. That's you.
In regards, I guess, to the president's power in emergencies, and then also, I guess, to Professor Mortenson's how enumerated does Congress's instruction have to be? If you look at the first and second Barbary Wars, if I'm correct, I don't believe either were declared by Congress. However, there were naval acts that gave the president discretion in regards to the Navy.
I love reading Jefferson's instructions to the flotilla that he sent. Go out there and sail around and, have a look here, have a look there. If by any chance somebody should happen to fire upon you, then you are to defend yourself with, and then he lies to Congress about what happened when the engagement begins. He lies about the sequence of events and makes it sound purely defensive in a way that it was not. So it's interesting, right? Hypocrisy is the homage of vice pays to virtue. Making the moves, framing them in the way that he did, lawyer's gonna lawyer, but think about the framework for how to talk about presidential power under the Constitution that represents, in my view.
Julian's quite right about Jefferson in this, but it is true that Congress did not declare war, but they did pass a statute authorizing the use of force in this naval conflict. And I don't think, unlike in the Vietnam War, which is authorized by the by the Gulf of Tonkin resolution without a declaration, a number of people began to say, no, the president can't commit troops unless there's been a, quote, declaration of war, unquote. But I think the Barbary affair indicates that Congress doesn't have to use the magic words, declare that an authorization is good enough. And an authorization is quite different from a declaration, because a declaration of war compels the president to go to war and to bring the war to a successful conclusion. That's what the declaration meant. An authorization enables the president to go to whoever it is and say, unless you stop doing this, we're going to go to war, and I already have authorization to go to war in my pocket. The bombs will start landing tomorrow. So authorization, I think, just like the various George Bush wars were authorizations for the use of military force. There were some people, Rand Paul's father, one of them, who said that's not good enough. I think that was good enough, and in fact, I think it's a really flexible and intelligent way to go about that sort of thing. Now, that's not to say that you can then fight everybody in the Middle East till forever on the theory that they were related to Al Qaeda, whether they were.
How about Canada?
Well, I might make an exception for Canada. You know that the Articles of Confederation provided that Canada could be admitted to the United States. They had a right to be admitted to the United States, and I think some people thought that they would love that invitation. There was no mention of Greenland, though.
All right. With that, we are out of time. So thank you all for your great questions, and thank our panelists.
Thank you again, Judge Larsen, Professor McConnell, Professor Mortenson. That was excellent. Thank you all for being here. Thank you, too, to our AV team and all the symposium team members who made those slides happen and made everything work on time. Let's give them a round of applause. Before we go to our break and our last panel, I have been informed there are still a few banquet tickets floating around. You're not going to want to miss it. The Jack Roth Club at Michigan Stadium is beautiful. If you want one of those, you have 30 minutes left to go back to the registration table and get that taken care of. You will not be admitted into the banquet unless you have a B on your name tag later. So if you would like, check if you do, and if you don't have a B and you would like one, please go in the hallway and obtain one of those. 15-minute break to our last panel. Green, Grove, Primus, Tyler, Whittington, and Judge Kethledge.